Court rise. Application and appeal in the matter of the Queen on the application of Cornerstone, North East Adoption and Fostering Service Limited and the Office for Education, Children's Services and Skills.
Yes, Mr O'Neill.
My Lord, my ladies, in this matter I appear on behalf of the appellant and claimant with my learned junior Mr Silverstone, and Ms Hannett, QC, appears on behalf of the respondent Ofsted. This case has been set down for 2 days, but the court will have seen that I have actually prepared, burning the midnight oil, a speaking note as to what I would be saying, and if it was any assistance to the court, I've prepared copies of that and circulated them. If I stick to that, subject to, of course, the court's questioning on matters, I would hope to finish by lunchtime, which might mean that we would finish by today, depending, of course, on Ms Hannett's approach.
All right. Well, that takes us directly to what I was going to check with you, whether you would agree to division of the time. If you think you're going to be shorter than the day that, roughly speaking, you would have expected to have, then all well and good. But we'll work through it. Can I firstly, as it were, formally thank you for the speaking note and appreciating the work that must have gone into it. Just say this, as a matter of fact, we're going to put it to one side. We received it at around about 10 o'clock this morning. We haven't read it, and obviously it's not a moment to start reading a document of 50 pages. And it seems to us that, although we fully accept that it's provided in good spirit to help the court, that in fact we have a rule in the court that skeleton arguments will be 25 pages long. And insofar as the speaking note helps you, then all well and good. But I think we'll stick with your, as it were, court-approved documents, and we'll have it here. But don't take it that we're going to read it or refer to it.
I'm obliged for that clarification, my Lord. It was in fact written simply for my making sure I knew where I was going with it.
All right, but I can see that in the court below, for example, the judge was feeling it appropriate to dot between the skeleton argument and the speaking note and so forth. We won't be doing that.
No, that's perfectly understood. So, in against that background, then, Lord and ladies, I do formally adopt the written note of argument, the skeleton argument which we put in, and really was hoping to use my oral submissions primarily to highlight 2 main point contradictions in the approach which we've said result from the decision of Mr Justice Julian Knowles, and also to respond to points raised in the respondent speaking note. If I may then start, and I'll follow the particular grounds of appeal.
Can I just, I caught you to say the respondent speaking note.
I'm sorry?
Yes, that there isn't another document floating around that we haven't seen. No?
I haven't got one.
We're being live broadcast. I'm sorry, I responded to skeleton argument.
Yes.
There is no other document.
Yes, indeed.
So, as I say, my intention is to follow the structure of those grounds of appeal which have been permitted in this matter, and again in the light of the court's ruling yesterday, which allows the evidence of the Reverend Mason to be referred to.
Yes. So I think we've achieved a situation where we've cleared the decks for you to deal with the 5 grounds of appeal without us having to go through ancillary matters.
That is very helpful. So, as I say, dealing then first with ground 1, which in a sense is the most substantive ground in this, and perhaps raises the most interesting and perhaps difficult questions, certainly new questions, relatively new questions for the court to deal with. And that is basically the proper relationship between the role of the Charity Commission as the statutory regulator for charities, who is empowered, obliged under section 193 of the Equality Act to perform particular regulatory functions in relation to charitable bodies in relation to Equality Act matters, and the role which Ofsted sees itself as being able to adopt, which is to effectively do an Equality Act and Human Rights Act review of this appellant, Cornerstone, because it is not just a charity, but also is an independent fostering agency. Separately, it has also applied to be a voluntary adoption agency, but that is a separate matter, and that's simply for background for the court, and that application is on hold pending some of the issues being resolved in this appeal.
The point raised by Ground 1 focuses on the equalities legislation and Ofsted's competence in that field where the Charity Commission has expressed a view or registered an organisation. If you were successful in relation to that argument, where would it take you in relation to human rights arguments?
It would, I say, when we look at the case law, it would mean that we, as it were, there was no further investigation into the lawfulness of our position, because the if one wins on the Equality Act point, that involves carrying out a proportionality test under section 193 subsection 2A, and that proportionality test is the same as would be required under Article 14 in relation having regard to Articles 8.
Yes. One thing that we, if it isn't too basic, an inquiry, during the course of your submissions, we'd be interested in any passing observations that either of you have about the structural process that takes place in these cases, where an investigation has to be carried out both under equalities legislation and under human rights legislation and convention. And we would be helped by anything that you'd like to say, even at a very basic level, and forgive me if it's trite, as to what we're doing, going through all these things twice. Is it simply because it's there and it has to be done? Or is there something distinctive about the inquiries that are being carried out, for example, on the facts of your case? So don't let me turn you out of your way for the moment, but just when we look and we see that we have a series of grounds, and as you've said, it may very well be that the two return the same answer.
But it's an important point, my lord, and I'm happy to address
whenever it seems good to you.
It is an important point, because clearly this case arises out of Ofsted's approach to our application of these requirements for foster carers and employees. In the report as initially, the initial draft report, Ofsted said that the requirements on foster carers were, the requirements as related to foster carers were lawful under the Equality Act as regards religious requirements. That was Ofsted's position. And they said that from the outset because under the terms of paragraph 2 of Schedule 23 of the Equality Act, there is, we don't need to turn it up immediately, I'll just deal with that now. There is provision for organisations with religious purposes to put forward requirements in relation to religion and belief, which are required by the religion, the organisation's purposes. And Ofsted ultimately, frankly, a little bit reluctantly, accepted that we were a religious organisation for the purposes of paragraph 2 of Schedule 23, and that we fulfilled the requirements set out in paragraph 2 subsection 6 of Schedule 23, and that therefore our requirements insofar as related to religion or belief were lawful and could not be impugned for otherwise breach of the Equalities Act.
So you couldn't be impugned for requiring carers to be evangelical Christians?
Under the Equality Act,
Under the
because of the provisions of paragraph 2, subsection, subparagraph 6 of Schedule 23. But in order to get round that, the fact that we were protected, and they accepted that we were protected as a religious organisation with our religious requirements under the Equality Act, they said, nonetheless, you are in breach of the Human Rights Act, Articles 8 and Article 14, because you are a hybrid public authority who is carrying out a public act for purposes of Section 6, subsection 5, and you cannot claim those specific protections which has been afforded by Parliament under Schedule 23 of the Equality Act, because as the Human Rights Act, as it were, is an alternative route into impugning your religious requirements on foster carers. So it was Ofsted bringing in the Human Rights Act because we were, as it were, we had a shield with the terms of paragraph 2 of Schedule 23 of the Equality Act. And ultimately the judge said, well, that can't be right. You cannot be able to use the Human Rights Act in a manner which undermines what the clear protections afforded to religious organisations under paragraph 2 of Schedule 23 of the Equality Act, and that therefore, on that basis, that one cannot be allowed to undermine what Parliament had carefully put in place, therefore any proportionality test required under Article 14 would be deemed to have been met and justified.
So there's an instance, in a sense, of convergence, as the judge found, on the religious element. So the two yielded the same outcome, and that is not a matter that's before us. I'm just wondering whether, in the case of the issues that are before us in relation to the discrimination allegations and findings, whether there's ever any possibility in circumstances of this kind of the two different inquiries under the equalities and human rights legislation yielding different outcomes.
There potentially is, because we're dealing with different statutes and different wording.
But will they in the end not all, as it were, end up at the terminus of proportionality? Is that, or is it possible that along the way there will be a siding of exception of this kind or exception of that kind into which the train might travel?
The exception for proportionality would only apply if this court were to read into paragraph 23, paragraph 2 subsection, paragraph 10 of Schedule 23, a proportionality requirement, which is not there. In fact, going on to, and that's where the complication comes in, because under paragraph 2.7 of the Equality Act, it is possible for requirements to be placed by a religious organisation relating to sexual orientation. And that isn't subject to any proportionality test at all. It's just the same test as before, as set out in paragraph 2 subsection 7, which is it's necessary to comply with the doctrines of the religion in question. And there is no proportionality analysis required of that. But in this case, of course, and that's where the battle was drawn, lines were drawn in the court below, we said we can still pray in aid in relation to, if in insofar as you say we are discriminating grounds of sexual orientation, paragraph 2 of Schedule 23, because these requirements are imposed by reasons of the doctrines of religion. And similar arguments, of course, were made in Pemberton, as you may recall. And the response from Ofsted to that was no, because there is a specific let-out specific to sexual orientation in subparagraph 10, which says that if you are acting on behalf of a public authority, a local public authority, and in pursuance of a contract, then you cannot pray and aid the sexual orientation absolute let out, and therefore you have to then be subjected to the normal standards of is this direct or indirect discrimination, which is why those issues are now before this court on the sexual orientation matter. So that's why, whereas under the Human Rights Act and the claims of breach of Article 8, read with Article 14, there is always a proportionality analysis, whether it's direct or indirect discrimination. So that's where we can see a divergence.
Well, before I step back and allow you to develop the grounds, would it be right at least to understand that however one articulates the focuses of each of these two sets of legislation, it would be surprising if one reached one conclusion on one but a different one on the other?
It would be surprising, and indeed that is effectively what impelled the court below to say that I will reach the conclusion which I have reached in terms of religious requirements for the purposes of Human Rights Act as well as the Equality Act.
All right. So if it means we're simply travelling roughly the same road twice, that's just how it is.
And the court will note, of course, that certainly in Ofsted's skeleton argument, certainly in Ofsted's skeleton argument, they deal with grounds 3 and 4 as they were.
Yes, quite briefly.
One. Yes, but no, they join them together. They're about, is this indirect discrimination justified under Section 19, and or is it justified under Article 14? And they deal with them as if they were the same proportionality test. And frankly, I think that's correct.
Right. That's very helpful. And obviously, if Ms. Hannett has some thoughts about this sort of blue sky thinking, then she'll let us have them in due course. Thank you, Mr. O'Neill. Now, you were going to work on now with Ground 1.
I was, but this has been useful. This discussion is useful in clarifying some of the complexities, I think, around Schedule 23, paragraph 2. But what we're dealing with in Ground 1 is Section 193, and if we're right on that, then luckily we don't have to get into the issues around the relationship in paragraph 2 of Schedule 23 and the Human Rights Act, because Section 193 provides a complete defence and a complete exception to charities if they comply with the requirements of Section 193 from any breach of the Equalities Act. And if there's no breach of the Equalities Act, it is certainly the case law relating to that will say, and it would be a very surprising and unusual and unprecedented result, say yes.
Do any of the other grounds survive if you were to succeed on Ground 1? Do any of the other grounds need consideration?
They don't, actually, no, because ground 1 is, Section 193 is a complete defence.
Right. And you don't need, for example, Ground 5?
I don't mind getting Ground 5, but it depends on whether the court is agreeable to the idea.
Well, we're going to express a view on every ground.
Yes, of course.
Whatever our view is on Ground 1, lest we were to be wrong on Ground 1. So I just need to know for analytical purposes whether Ground 5, in fact, would survive, as it were, even on your reading.
Yes, formally it would survive, and I'm sorry, I rather took it as shorthand on the
Yes.
basis of our earlier discussions that if you win on the Equality Act, you're unlikely to lose on the Human Rights Act. But formally, yes, it would survive as a
Whereas
Human Rights
grounds
Act
2,
offence.
3 and 4 wouldn't even need consideration on your analysis.
Certainly grounds 2 and 3, because they are about direct discrimination on grounds of contrary to section 13 of the Equality Act and indirect discrimination contrary to section 19. Ground 4 formally is the Human Rights Act ground, as we've said to have breached Article 8 of prospective foster carers. So, but certainly 2 and 3 go if we're focusing solely on the Equality Act issues. But if one wins on the Equality Act, as I say, it's unlikely that the Human Rights Act would produce a different result.
Thank you.
So, as I say, section 193 then is this complete defence, and it provides that a person doesn't contravene this act. I don't know if it's worth having the precise
Yes,
wording
please.
of that.
Let's get it up.
Yes, apologies. Having offered that, I then have to. It's in tab 4 of volume 1 of the authorities.
It's page 73, Mr O'Neill.
I'm obliged, lady. Sorry, I normally do have these things.
Sorry, 73, yep.
Thank you.
So it says, as we see, and the relevant provisions are sections 1, 2A and 8. So that a person does not contravene this act. Now that's the important point, does not contravene this act. Only by restricting the provision of benefits to persons who share a protected characteristics, if the person acts in pursuance of a charitable instrument, and, reading short, the provision of benefits is a proportionate means of achieving a legitimate aim. We are not claiming the separate test under 2B, which was discussed in the Zedd and Hackney case in the Supreme Court. And also, one notes the terms of section 8, subsection 8, charity regulator, which is at page 74, does not contravene this act only by exercising a function in relation to a charity in a manner which the regulator thinks is expedient in the interests of the charity.
Right, so that's the Charity Commission.
Yes. And the relevant regulator is, of course, set out in section 194, which is 194 subsection 5, the charity regulator is the Charity Commission for England and Wales in this case. So if we look then at section 193 and break it down into, as it were, an algorithm, we can ask a number of discrete questions. First of all, does Cornerstone restrict provision of benefits to persons who share a protected characteristic? And the answer to that is yes, in that Cornerstone restricts the provision of benefits which it provides, including what Ofsted has called its specialist faith-based support service to foster carers, to persons who share with Cornerstone the protected characteristic of religion or belief, more specifically evangelical Christianity, as defined more fully in Cornerstone's charitable instruments. The second question, so we've answered yes to that. The second question in the algorithm is, does Cornerstone act in pursuance of a charitable instrument when restricting its specialist faith-based support services to foster carers to those whom Cornerstone considers to be evangelical Christians? And again, the answer to that is undoubtedly yes, because we have the specific provisions in the charitable instrument, in particular the Memorandum of Association at clause 5, and again it might be worth looking at that. That's the supplementary bundle, tab 15, page 229, what I have.
I have difficulty with my supplementary bundle. The numbers go from 123 or so to 275. There's a jump.
Yes.
Also in my supplementary bundle.
Oh, I'm sorry. Sorry to interrupt.
No.
After you.
No. The Memorandum of Association starts on 227.
It does.
It's slightly confusing because there are two numbers in the bottom right-hand corner.
Yes, I have discovered that a large chunk of the pages are at the back of my file, so I do have it. Thank you.
Apologies for that. But yes, I'm sorry, my lady, there are two numbers on the hard copy, which is unfortunate. But
So we're looking at clause 5, are we?
yes, but the memorandum, as the court has pointed out, begins at 227. So it's worth starting at 227 because the objects clause is set out at clause 3, and that has been unchanged from the start, noting that the charity's objects are to provide a high quality adoption and fostering childcare service according to Christian principles, to alleviate the needs of children and young people who are or may be temporarily or permanently separate from their families, and to promote the relief and care of children without families or parents able to care for them by the provision of substitute families able to meet their needs with the aim of improving the conditions of life of such children and young people. So we see from the outset that the high quality adoption fostering child service according to Christian principles. That object has remained unchanged. In April 2007, in order to clarify matters, there was an amendment of clause 5, which is at page 229, and that states the policy of the charity shall be to restrict employment by the charity and acceptance of any applications to foster or adopt children through the charity to evangelical Christians, being those, and that's important, of course, because it's a defining clause, so we all know what we're talking about.
So we've got the amended clause here.
Yes.
Yes. Right, and the definitions are: you're an evangelical Christian.
And evangelical Christians being those who shall have first signed the statement of belief set out in the schedule. And that schedule is at page 230 to 231.
We'll come to that in a minute, will we?
Well, we can come to it now because.
Well, do you want to do B while we're at it? Because that also.
Yes, and I'll come to them separately. Then B is, so it's first signed the statement of belief set out in the schedule, and whose personal lifestyle, conduct and practice is consistent with the practice of the statement of belief set out in the schedule, and traditional biblical Christianity standards of behaviour as set out by the trustees in their code of practice issued from time to time, and who shall have first signed the said code of practice at the commencement of their employment, or in the case of foster carers or adoptive applicants at the time of their initial application. So there's, as we see then, the requirement of signing the statement of beliefs, and if we just look at those, page 230.
I'm sorry that I'm just taking time over this because it's such an important part of the case. But it seems that in order to be accepted by the organisation, you basically have to do two things. One is to sign the statement of beliefs and the code of practice, and the other is to be accepted by the trustees as being an evangelical Christian. Simply signing, I mean, it wouldn't be good enough if I, not being an evangelical Christian in the eyes of the organisation, was simply to sign the two documents and say, well, that's it. Because if it was your view that I wasn't, in fact, an evangelical Christian, that would mean that I would fall at clause 5.
It would be, and the criterion set for not being an evangelical Christian is not simply that you sign the documents,
Yes.
but that your personal lifestyle, conduct and practice is consistent with the practice of both of those documents, both the statement of belief and the code of practice.
Right, so it's basically signature and acceptance by the...
It's not enough to sign on the dotted line. One has to live, one has to witness and live consistently with what one has signed up to. It's not a formal box-ticking exercise.
All right, sorry, you were getting on now to the schedule.
Yeah. So the statement of beliefs is set out in pages 230 to 231, and it sets out a number of beliefs which seem to be characteristic of evangelical Christianity, really, since the Reformation. So first of all, it's Trinitarian, and secondly, it's to do with affirms the love, grace, and sovereignty of God. Grace is an important concept in this, of course, because grace is that which redeems, and it is made available by Christ's death and resurrection, but it has to be, one has to be called to fulfill the life of grace. I don't want to get into, I mean, the problem with this case is that theological issues are at the very forefront
No, but I mean,
of matters.
Of course, we don't want to either, but the statement of beliefs is in relation to matters of doctrine, what the trustees would use to identify somebody who was an evangelical Christian.
Yes, but it's absolutely central. It's perhaps the third statement in this, that the divine inspiration, supreme authority of the Old and New Testament scriptures, which are the written word of God, fully trustworthy
Yes.
for faith and faith and conduct. So there's an element.
Biblicalism is at the heart of it.
Biblicism, some might call it biblical literalism, but
Yes.
certainly it's sola scriptura at some levels.
Right, but that's helpful in relation to beliefs, doctrines, as it were, that sets out the scope of what the organisation considers to amount to Christianity of an evangelical kind. And then we come on to behaviours, do we?
Yes, but as a highlighted, one has to live in accordance and compatibly with that statement of belief as well. So one has to live, has one's personal lifestyle, which is compatible with accepting and living the claim that the divine inspiration, supreme authority of the Old and New Testament is fully trustworthy for faith
Yes.
and conduct.
That's
So,
point B.
that's a central issue, because of course, as the Mr. Mason, Reverend Mason's statement makes plain, that the references to what might be called homosexual lifestyle within the Old and New Testaments are certainly none of them positive, and such ones as there are, they may be said to be limited, are uniformly negative, some of them in quite strong terms, in fact.
Well, his evidence is that it's not possible to be a gay evangelical Christian.
It's not that in a sense is a shorthand. It is not possible to be an evangelical Christian who disputes the primary authority of Scripture, which condemns homosexual practice. and therefore, by implication, if one is in a same-sex relationship, there is an incompatibility or an inconsistency within what you say you've signed up to, which is the supreme authority of Scripture, and how one lives that out.
Well, you extrapolate it in that way, and I fully understand how you put it, but is there anything inaccurate in my, as it were, shorter route to the same?
Well, potentially, because it's not because one's gay, it's because of what's called a gay lifestyle. It's to do with behaviour rather than simple orientation.
Right, so maybe more helpfully, you couldn't be a gay couple and present yourself to your organisation as evangelical Christians.
Or a sexually active
Gay couple.
or a same-sex sexually active individual.
Yes, and you'd also fall down if you said, well, actually we're abstinent as a couple sexually, or I'm abstinent as an individual. But I am gay, and I don't happen to believe that the Bible prohibits homosexuality.
Yes.
That again would be a red flag.
Yes, my celibacy choice is simply a personal matter. I'm asexual, I happen to be gay,
Right.
but I really don't believe what you said.
That's not
the
good.
Bible condemns it. But pushing that further, if one says, actually, I absolutely accept that the Bible is condemnatory of same-sex sexual behaviour, despite my being gay, I have avowed to be celibate as an individual, and my life shows that.
Right, at that point people would put their thinking caps on.
Well, it would show that this is not about sexual orientation, because it's about sexual behaviour. And there are certainly in the literature, there are, particularly in evangelical circles nowadays, a lot, depends what one reads, material relating to the idea of being fully evangelical Christian, gay and completely celibate.
Right, but your organisation is not on that wing of the argument. You would see yourselves as being conservative traditionalist in that respect.
Well, that isn't a contradiction with conservative traditionalism to say that one can be, one has been, that one's sexual orientation is the way it is, but that one considers it not to be part of God's plan for that to be expressed in sexual activity, and that one accepts that some levels the sexual orientation that one has been given by God is not one that can properly be acted on in terms of sexual activity in accordance with God's plan, because that's what the interpretation of the Bible tells one. So that's not a non-conservative view. That's a totally consistent view, which we would hold as much as any other. And the importance of that is that it points to what the concern is, and the concern has always been, and that's what's been the position taken before the Charity Commission, but it's been classically taken by Christian churches, is that it's not orientation that they're concerned about, it's behaviour.
It's behaviour and belief.
Yes, I was assuming that one had signed up to belief, but of course, yes.
Yep.
And it's difficult, again, to separate, and in a sense this is part of what it is to be evangelical Christian, is that one doesn't separate. Belief is not something in one's head. Belief is expressed through life. One is expressed in word and deed. And part of the position which we're taking here is that the charitable activities, the very notion of caritas, is one which is a manifestation, an expression of these religious beliefs, which is why the clause 5 says one has to live in accordance with the statement of beliefs, as well as the code of conduct.
So it might be more helpful to note behaviour/belief as being in
behaviour in accordance with belief. Is perhaps the best way of.
Right, you were going to go on, I think, to the.
I was just going to say, without wishing in any way to be controversial, that what you're actually saying is one has to not only talk the talk but walk the walk.
That sums it up absolutely. So walk the walk in grace. Yes, but just staying for a moment with the statement of beliefs, because it is seen that one has to live in accordance with that. It is important that one sees that issues around sinning and repentance are central to this context. So, clause 4 notes the dignity of all people made male and female in God's image to be holy and care for creation, yet corrupted by sin. That's one of those specific Reformation tropes, picking up from some things that might have been said by Augustine of Hippo, but that there is a complete corruption by sin of all, and all are required to and can be saved only through the atoning sacrifice and grace resulting therefrom, freely given by God to those. Nobody deserves to be saved. Everybody is in a situation of utter corruption by sin. And the justification of sinners is solely by the grace of God through faith in Christ, as is set out in paragraph 8. And paragraph 9 notes the ministry of God leads us to repentance and a new birth. So there is this notion of conversion as being central within the evangelical tradition. It's not enough to be, as it were, a nominal Christian, a baptized Christian, as somebody who, but there is a personal repentance, a personal new birth, and that is what creates discipleship. And following that, then, of course, as I say, the issues 11 of the statement of belief in relation to the purpose of God being fulfilled by ultimately bringing all people to judgment, giving eternal life to the redeemed and eternal condemnation to those who are lost.
But
So,
walking the walk is set out in the Code of Practice.
More specifically, but I have spent some time on the statement of belief because that has been told, that's been told to us as being something which has to be lived as well. But yes, the Code of Practice is at page 244, 245, and specifically 244 is the Code of Practice for employees, and there's some very slight differences between that and carers. But the one that we're interested in, because the application of the Code of Practice to employees has never been challenged by Ofsted, is the carers one.
Right. Let me just get this right, because my numbering is slightly different. You're at what paragraph in the printed bundle?
Page
245.
245.
Right, thank you. So the previous two pages are the employees.
The previous page is the employees' Code of Practice, and the 245 is the Cornerstone carers' Code of Practice. And as we've seen in the clause 5, it applies. The Code of Practice is assigned to and complied with by both employees and by carers. Now this states that as Cornerstone is a Christian organisation, it's expected that all carers conduct themselves in a manner which will give proper expression to faith in Jesus Christ as Lord. The Code of Practice presents a brief summary of biblical teaching regarding Christian lifestyle and morality. The Bible, as the revealed Word of God, shall be the final authority in such matters. And the trustees will seek to give proper regard to the place of grace and forgiveness within a Christian organisation. And that's consistent with the notion of being sinners and repenting and seeking to throw oneself on the mercy of God.
So if you start as a carer but you fall short, then the trustees will have some latitude, depending on circumstances. But
provided that...
You're not going to start. You're not going to start as a carer if you've already fallen short.
Exactly. And the latitude, it has to be consistent with the requirements of Scripture and consistent with the statement of belief. And so therefore, as it were, an unrepentant or an unregenerate sinner would not, the trustees just wouldn't have the latitude to waive those issues, because they wouldn't be acting in accordance with their duties under the charitable instruments. So, as I say, they will also give proper regard to their duty to ensure that Cornerstone presents a consistent Christian witness. So there's therefore an expectation on all Cornerstone carers to sign the statement of belief and indicating personal acceptance of the belief stated, maintain a devotional life through times of prayer and Bible reading. And it's noteworthy that each of these requirements is, as it were, there's a scriptural citation, because again, we're on the sola scriptura aspects. This is something which is handed down and required by Scripture itself. Attend a local church fellowship, be in good standing, seek to be Christ-like in attitude towards all, regardless of race, social class, religious belief, or positions of influence.
So the interpretation is that the Bible protects many protected characteristics, but not the one with which we're concerned in this case.
Well, it protects the characteristic, but it's a question of whether it protects the behaviour. God is merciful to, it's a question as to whether or not any behaviour on that characteristic. And this is why we've always got to be careful, because that's a distinction which is constantly being collapsed by Cornerstone, but by Ofsted, but it's one which is central to the understanding of Cornerstone's evangelical Christian approach. I mean, it might be said that as said by some scriptural scholars, that there wasn't a concept of a different sexual orientation at the time of the Old and New Testament. All there was a notion that some people engage in certain behaviours and they should not be doing that. But there it is. There's honesty in all manners of money and financing, honesty in speech, avoiding blasphemy and profanity, maintaining a home and working environment free from harassment, bullying and victimisation, abstaining from the occult, maintaining a lifestyle recognises the effect of alcohol in the body and avoiding drunkenness and substance abuse. So we can see there's a whole series of specific injunctions, all of them taken from scriptural passages. And then we come to 10. Set a high standard in personal morality, which recognises that God's gift of sexual intercourse is to be enjoyed exclusively within Christian marriage. Now, I emphasise the Christian marriage aspect here, because it's, again, this is something which came up in the Pemberton case, as Lady Justice Asplin knows, and what constitutes Christian marriage is, and we'll come and unpack that, is a lifelong commitment between one man and one woman. And it's a religious requirement. It's Christian marriage. So God's gift of sexual intercourse is to be enjoyed exclusively within Christian marriage. Abstain from all sexual sins. All sexual sins are activities outside the bounds of Christian marriage. And that would include, and I've said, out immodesty, viewing of pornography, fornication, adultery, cohabitation, homosexual behaviour, and willful violation of your birth sex. And then there's a next requirement to give proper regard to the laws of the land.
What is the last requirement? It's to do with what, gender identity issues?
Willful violation of your birth sex. Well, if one looks at, I think the quoted passages in Deuteronomy, it refers to wearing clothing other than one's...
Transvestism?
Yes, and it might be ritual transvestism at the time, but so one has to, yes, I mean, it's a scriptural injunction not to act in might now be called a gender inappropriate manner, or
Right, but
terminology nowadays is so difficult to
Yes.
process.
Well, it's not what we're
Let's just stick to what
directly
they say.
concerned with
Yes.
here, but the headline of the clause is setting a high standard in personal morality, and then the clause goes on to identify what the organisation considers that this requires, and there are a number of indicators, which is only sex in a marriage between a man and a woman, and not in any other circumstances.
And even within such a marriage, the sexual sins are not to be viewed, so therefore not
Yes.
viewing of pornography, immodesty.
Exactly. So homosexual behaviour is not acceptable either within or without a marriage.
Yes. And in any event, as we develop the same-sex marriage, although recognising that law of the land is not a Christian marriage.
Yes.
And this is not an exclusive list.
No, it's the, as is noted, the abstain from all sexual sins, including, and there are just particular specifications under reference to specific scriptural passages.
Yes. And 11.
And 11, yes, that's it.
I can't fail to see what it says. Yes.
Well, it's a very
I
interesting...
think what this case may be about whether 10 and 11 are compatible with each other.
The interesting thing is proper regard to, rather than blind obedience to, and that's important.
Well then that may lead you into all sorts of theological debates about obeying the law of the land, whatever it is.
Absolutely.
So perhaps we shouldn't go there.
Perhaps we shouldn't. Indeed, it is be mindful of the lawful authorities, and it was a major Reformation trope, as one knows, Luther attacking the peasants' uprising on the basis that they were breaching Romans and that they weren't properly regarding the lawful authorities. But of course, it was also the Anabaptist rebellion and the like, where that there is no authority higher than God. So there are very, very big issues
Yes.
there.
Render unto Caesar.
There is the render unto Caesar,
Absolutely.
but render unto God, and God
Yes.
may require. But we don't need to go there, luckily. But it is very much pay due regard rather than blind obedience to, I think. But that is.
All right. That's helpful.
So
you have to sign that when you are accepted as a
no, if you make an application before you're accepted, I think that's what.
I see. So that would go with the application process.
Yes. As you've seen, clause 5b at page 229 says, in the case of foster carers or adoptive applicants at the time of their initial application. So we've answered the first two questions set out in 193, in that we are restricting the provision of benefits to persons who share the protected characteristic of religion or belief, in this case evangelical Christianity, as set out and explained in the Memorandum of Association, which is a charitable instrument, so we are acting in accordance with that. And that just therefore leaves perhaps the big question of 1932A, as in, is Cornerstone's restriction of its faith-based support service, which is one of the benefits, to foster carers whom Cornerstone accepts to be evangelical Christians because they have signed up to these matters and are living in accordance with those documents. A proportionate means in achieving a legitimate end. Now, that is the question which the Charity Commission addressed itself to and answered yes. Now, Ofsted don't like that. They say, oh, well, the Charity Commission got it wrong. What do they know? They're a Charity Commission. They're not equality specialists. I can see neither are Ofsted. Equality and Human Rights Commission is perhaps the equality specialist. But it is clear from the documentation that the Charity Commission did address that question.
Right. Shall we just, would this be a convenient moment to run through the correspondence on that?
Absolutely, I was about to go to that. So we go to page 247, in the funnel, tab 19. And that's a letter of 26th of November 2008.
So just going forward, does this run between 2008 and 2010 or 11?
2011, and again, the significance of it runs to
It's
January
post-Equality Act.
It's post-Equality Act because that comes into force on the 1st, the relevant provisions come into force on the 1st of October 2010.
Right, so just 2008 to 2011, and these were at
tab 19, well, it starts at tab 19 and then...
Right, so we've got basically, I'm just looking at the tabs before we dip into the... do we dip into this? We've got an exchange of about half a dozen letters.
Yes.
Over a 3-year period, or thereabouts.
Just over 2 years, 2 years and 2 months. But the correspondence is, of course, around the time of and made under reference to the Catholic Care Father Hudson decisions, which we will come along to look at. But the tabs are from tab 19 to tab 24, pages 247 up to 259. It is important to look at them, I'd say, in sequence to understand where they're coming from so that we know what was being considered by the Charity Commission. First of all, in their letter of 26 November, which is at page 247, they note from press reports that there was a change in the Memorandum of Association in April or May 2007. We've seen that was clause 5, although clause 3 had remained unchanged. Simply clause 5 was bringing into line foster carers with the existing provision in relation to employees. The Charity Commission understands the purpose of the change was to take advantage of an exception contained in Regulation 18 of the then regulations. That is a provision which is quoted more fully in the cases, but that is the predecessor provision to section 193, which we're considering, but it's not in precisely the same terms, and it specifically relates to and only to, at this stage, sexual orientation. So you note that the Charity Commission was contacted at the time and replied, but then in relation to what was meant by Regulation 18, they've now reconsidered matters having regard to Catholic adoption agencies. And those Catholic adoption agencies are Father Hudson Society and the Catholic Care. Now, at that time, the reconsideration which the Charity Commission had made was that Regulation 18 could not be relied upon in terms of to have a sexual orientation requirement in relation to adoptive parents or foster carers, because they were not the beneficiaries of the charity. They weren't receiving the benefit of the charity. The benefit of the charity was being received by the children, and so therefore you couldn't apply that provision to foster carers. So they're saying, so you thought you could, we thought you could, the Charity Commission, but it turns out we thought about it a bit more and we think we're wrong. So, as it
Right,
says,
so the purpose of the letter is to bring to attention the decisions in the Catholic cases
by the Charity Commission.
by the Charity Commission, and to say that because you are affected by these decisions that we have taken, you have a right to appeal against them.
Yes, because this will, as you say, the decision is relevant to your charity because it is attempting to rely, as the Charity Commission understands it, rely on the Regulation 18 exemption for sexual orientation in relation to foster carers.
Right. And we've decided in other cases that that doesn't cover you.
Yes.
You may wish to appeal.
Yes, so
Right.
you should know about this.
Right, so insofar as there was consideration of this in the Catholic cases, that's what was decided in those cases, and there's then litigation about that. But insofar as it's deciding anything in this case, it's simply alerting Cornerstone to what's going on.
Yes. And the Catholic cases go on in a fairly complicated way, but it's interesting and important to note the next response from Cornerstone at page 249, immediately saying we're not in the same position as the Catholic cases. The Catholic Care and Father Hudson cases are doing something different from what we have done.
Right, because it's our belief that we rely upon here, which is that this is not acceptable form of Christian observance and behaviour, may be different for Catholics.
Not quite. Because we have put forward a religious requirement which covers a whole series of matters, and foster carers have to be fellow religionists, fellow evangelical Christians.
Yes.
And all we've done is spelt out what it is to be an evangelical.
And in the end,
Christian.
it's the response is, well, this may be true for Catholics, but it's not true for us.
No, because the Catholic Care, interestingly, and Father Hudson's do not put in and have not put in a religion-based clause. They do not say you have to be of a particular religion to be. You do not have to be Catholic to be. What they say, however, somewhat misguidedly, is that they want to change their memorandum of association so as to discriminate on grounds of sexual orientation. We will not provide adoption services to homosexuals. We'll provide them to non-Catholics and Catholics. So it's not a religious requirement. It's a requirement it's an attempt to discriminate on grounds directly of sexual orientation, albeit it says it's motivated by religious concerns. And that's the central difference in this case, and it has to be held on to. Because again, Ofsted confuse matters. They say, well, not every discriminatory act which is motivated by religious belief is protected. And that would be right in terms of what Catholic Care and the Father Hudson Society were attempting to do. They were simply saying, we're not imposing a religious belief requirement, we're imposing an orientation requirement. And orientation, not behaviour, orientation, we will not let homosexuals adopt. Now, the reasons they give for that are religious ones, motivated by religion, but they're not a religious requirement being imposed. Whereas we, as we say from the outset, we've always said we are an agency who employs and uses as foster carers only evangelical Christians.
So you say it's a religious requirement of yours to exclude homosexuals.
No, we don't say that. As I keep on coming back.
Well, I'm sorry if I keep trying to boil it down to what it means.
Well, but I keep on coming back and saying it's not about homosexuals. It's about maintaining Christian standards of sexual morality, among which there are various sexual standards, among which would be homosexual behaviour. But people who are homosexual, have a sexual orientation, can abide by those Christian standards of behaviour by being celibate. So it's not against homosexuals by reason of their orientation. It's one of the implications of restrictions on sexual behaviour, whereas in the Catholic Care and the Father Hudson case, it was about homosexuals. Therefore, my Lord is right to use the shorthand there, because it says, as we'll see from the case, it says in terms, we want to restrict our adoption service so that we will not have to allow homosexuals to adopt.
But before you said it wasn't just about being celibate, it was also about the statement of belief.
Yes.
So it's a belief and celibacy.
Yes, it follows.
Yes.
Yeah. We don't need to get into.
No, but you're sticking by that. It's,
yes, it's belief.
It's belief and practice.
And practice. Because practice shows what you believe, but it's a belief requirement, which has implications for practice. And if you're not practicing, then it shows you're not believing, which shows that you're not an evangelical Christian, which shows therefore you haven't complied with the religious requirements. Whereas Catholic Care has nothing to do with that at all. You could be any religion whatsoever and still apply to Catholic Care because they had a. But the one thing is, if you say, "But I'm Catholic and I'm gay," well, they say, "I'm sorry, we're not going to allow you to adopt." And that's precisely, in a sense, the issue which the judge below fell down into, because he refers to, in the Catholic Care case, the fact that the lesbian and gay caucus, the Roman Catholic caucus of the lesbian and gay Christian movement had written specifically into to dispute the then Bishop of Leeds approach, saying, look, we are. If you want a religious requirement, you can be gay and Catholic, and you can dispute the Bishop of Leeds' interpretation of what it is to be gay, and unfortunately, Mr Justice Knowles below then applied that understanding wrongly to the religious belief requirements of evangelical Christianity.
Right. So here is your letter seeking to make that distinction between the two set of circumstances.
Yes. As you see, I note from the Catholic adoption agencies were seeking to adopt a new objects clause which limits adoption service to heterosexuals, whereas Cornerstone had changed its memorandum to make the existing Christian basis ethos clearer, and that was just an alteration of clause 5 rather than, and the objects of the charity remain unchanged. And that
so effectively, the judge found that this was a distinction without a difference, whereas you say it's an important distinction.
No, I don't think the judge was aware of the distinction, because the reference to what was said by the Roman Catholic caucus of the lesbian and gay Christian movement didn't appear at all in argument before him. That was something which he picked up on alone, without having heard argument or discussion, and just put it in his judgment because he picked it up from what was said in one of the Catholic Care decisions. So he didn't. That's why his judgment.
And you're saying, first of all, it's a religious requirement here, whereas those cases were directly in relation to sexual orientation. But you're also saying, I think, you can be an evangelical Christian and also homosexual, but if you, in being so, you have to accept that that is a form of sexual immorality, because that is part of the statement of beliefs, and you also have to be celibate, because that's part of how it works out in your life.
Yes, it's a cross which you bear. I mean, people are given various crosses, and from an evangelical Christian perspective, orientation, and insofar as it is there and it's true, is one of those things one has to live with, but all of us are called to live in accordance with the Christian standards of morality.
Yes.
So is that why, in the Code of Practice, at Clause 10, the specific reference is homosexual behaviour?
The specific reference to homosexual behaviour is there because it's as your Lordship pointed out, it's a list examples of sexually
Yeah, I have that, Mr.
wrong.
O'Neill. The short point is it homosexual behaviour?
Yes,
Because it takes account of someone can be a homosexual but celibate.
yes, yes, and the homosexual behaviour was a reference to what's said in Leviticus. So, and they note in the letter that the Charity Commission had approved those changes the Memorandum of Association has been acting on it since 2007. And it's been a settled part of the charitable instrument since then. We then get the next letter of the 30th of December 2008, page 250. And there, in effect, the Charity Commission clarified it's not questioning the legitimacy of the change in clause 5, but it was simply, it considered that clause could not be prayed in aid as exempting foster carers, as it being applicable to foster carers in relation to allowing for an exemption on grounds of sexual orientation. And that was, as we've said, because of the specific and peculiar interpretation of Regulation 18, which the Charity Commission had recently reached, which is that foster carers were not in receipt of charitable benefits, but only children were. Now, there's a gap in the correspondence because there are other things happening in the background. And what is happening in the background is that on the 13th of March 2009, the Charity Tribunal said that no, the Charity Commission have misunderstood Regulation 18. It can be prayed in aid by the foster carers and adoptive parents. It's not restricted to the notion of who receive charitable benefits under instruments. Is not restricted to children, but also can be prayed in aid by foster carers in relation to foster carers and adoptive parents. So the new interpretation, which the Charity Commission had adopted, was found to be wrong by the Charity Tribunal. And the reference to that, if needed, is in the Father Hudson Society case at tab 9, page 181, paragraph 53. And they say, it's a broad notion of charitable benefits under a charitable instrument. It allows for what they describe as a knight's move, which is to say that we cover not just children, but the ways of giving benefits to children by appointing foster carers in a particular way. So therefore foster carers fall within what is now the section 1931 provision of benefits approach. And that decision of the Charity Tribunal on that point was upheld by Mr Justice Briggs, as he then was, in the Father Hudson Society decision, and that's at tab 14, page 353, and he upholds that at paragraph 104. And just in brief, he says Regulation 18, which is now Regulation Section 193, applies potentially to all types of benefit provided to persons of a particular sexual orientation pursuant of a charitable instrument, whether or not they are the supposed ultimate beneficial classes of that charity. So both the High Court and the Charity Tribunal have said to the Charity Commission, no, you have to go back to your original understanding of Regulation 18 as being able to be prayed in aid in relation to requirements on foster carers and adoptive parents, not simply in relation to children. And of course, under Regulation 18, all one is concerned with is sexual orientation requirements. So our position, Cornerstone's position, has always been we don't need that because we're not seeking to discriminate, unlike Catholic care. We're not imposing a sexual orientation requirement, we're maintaining a religious belief requirement. So, but what the decisions of the Charity Tribunal and the High Court meant on Regulation 18 was that effectively it meant that the Charity Commission had to go back and consider the justification aspect. In a sense, at some levels they were hoping to avoid to have to do all that, as is said in the judgments later on. But by this interpretation of Regulation 18, we were told no, it can be paid in relation to foster carers, and therefore, if it is lawful, it has to be. You have to check whether or not it's justified. So the next communication is on the 18th of August 2010. And I would say, of course, that the decision of Mr Justice Briggs is in March 2009, so it predates the coming into force of the Equality Act, but it anticipates its likely terms. At page 252, we have the next communication from the Charity Commission. And it refers to the decision of Mr Justice Briggs having quashed the Charity Commission's interpretation of Regulation 18, its narrow interpretation. Therefore, that meant that the issue of justification of the proposed change by Catholic Care had to be reconsidered by the Charity Commission, so the matter had been remitted to it. But the other thing they then note so having it been remitted to it, the Charity Commission also then advised, actually, this Mr Justice Briggs' judgment also makes clear that we have to apply a proportionality test in order to be human rights compatible. It's imported effectively from Article 14 jurisprudence. The Charity Commission say they weren't previously aware that that's what they had to do, and that's what Mr Justice Briggs' judgment requires. As you say in the penultimate paragraph, page 252, at the time Cornerstone amended its objects, well, it didn't actually amend its objects remained at clause 3. It amended, clarified in clause 5 things that followed.
Which page are we on at the moment?
Page 252. So the penultimate paragraph, at the time Cornerstone amended its objects, the Commission hadn't appreciated this, and it was only in the course of the Catholic Care decision the decision became clear. The implications of the decision are that an organisation which seeks to discriminate in a manner which is not justified under human rights law is not likely to be established for the public benefit. So we have a tie-in then of the public benefit test, which the Charity Commission is used to applying as having being requiring human rights compatibility. So the Commission, not having appreciated that before, hadn't reached a concluded view as to whether or not the religious requirements, restrictions for evangelical Christians as foster carers were indeed proportionate. So they're clearly saying we hadn't appreciated that at this time, but we now do appreciate it. So therefore, that is something which we want now to apply our minds to and reach a decision upon. As they say, page 253, in any event, even though it was spelled out in the judgment of Mr Justice Briggs, it's going to be made express in the terms of section 193(2)(a) of the Equality Act. So we are now going to have to apply that proportionality test. The letter goes on to note that section 57 of the Equality Act allows for religious organisations to impose religious or belief requirements. That is now, of course, paragraph 2 of Schedule 23 of the Equality Act. And they go on, it would therefore appear that if this exemption applied, the proposed discrimination is likely to be a proportionate means of achieving a legitimate end. So they say, if you can see that you pass the paragraph 2 of Schedule 23 test, then that will constitute proportionality, passing the proportionality test. And actually that is what the judge below also found. However, he makes an illicit distinction between you pass it for the religion and belief aspect, but you don't pass it for the sexual orientation aspect. Now I say that was a misunderstanding and misreading of what the implications of passing a proportionality test are under in terms of section 193. That you pass the test for all purposes. You are no longer contravening the Act at all. So it goes on, it appreciates that the previous alteration didn't require written consent, but that doesn't mean that you can avoid the proportionality analysis and test now being required to be made by the Commission. And they note that if that discrimination is then, even if authorised by the governing document, is unlawful, then that will have implications for you being able to continue as a charity. Now again, this is important because of course Ofsted say those restrictions are unlawful. And the judge has found that they are unlawful because in breach of sexual orientation discrimination. But that decision has been reached without any participation by the Charity Commission. It was never brought into this action. It was never asked to explain its decision. But it will necessarily have implications, not only for Cornerstone, if it's correct, for Cornerstone continuing as an independent fostering agency, but Cornerstone continuing as a charity. So you also note the High Court judgment is that if a person is turned away on ground, so individual victims can potentially claim whether on grounds of religion or sexual orientation and might be vulnerable to action. And in a sense this comes back to, and that's precisely what section 193 is about, is to protect, if charities pass the test, then there is no longer space for individual victims or Ofsted to come and try and reopen that issue, whether in the individual case of the particular victims or in Ofsted's hypothetical imagined victims. The point about section 193 is that if you pass the test, you are no longer able to be challenged on those grounds of unlawful discrimination. They also note the restriction on employment test, and that also, the question is, will that be covered by, it's now covered by Schedule 9, paragraph 2 of the Equality Act 2010. There are separate provisions in slightly different wording.
Yes.
We then come to Cornerstone's reply, and this is a long letter, but a very important letter because it's in response to that letter. It's adopting aspects of the analysis of that letter that one understands the ultimately decision by the Charity Commission of its, on 11th January 2011. So this is a letter dated 12th November 2010, so it is written after the Equality Act provisions have come into force, the relevant ones, section 193, Schedule 9, Schedule 23, they all came into force on the 1st of October 2010. And the following points are made among others. First of all, there's the reiteration that Cornerstone is not in an equivalent position to the Catholic Care Charity because they sought, as has already been noted, to be allowed to provide adoption services only to heterosexuals or not to homosexuals. Whereas, as we've already said, Cornerstone's sets out a religious basis ethos.
Why did Catholic Care wish only to provide services to heterosexuals?
Frankly, I think because the Bishop of Leeds took it upon himself by way of a crusade and was misadvised on the law. I suppose
But presumably it was arising out of religious belief.
Yes, but they had never imposed any kind of religious requirement, and they weren't then wishing to impose any kind of religious requirement. They didn't require any statement of belief or anything of the sort, because Catholic care traditionally had.
Yes, but, I mean, isn't the nub of this question as to whether these are simply two different ways to skin the same cat?
And that would be
and you
wrong.
say obviously it isn't.
Yes.
Because you've put your religious beliefs front and centre.
Yes.
Whereas Catholic care express themselves in a different way.
In a very clearly different way, because they never applied any kind of religious belief requirement at all. None whatsoever. Now, as I've said before, the difference, and it is an important difference, and it might well be central to the understanding of this case, is that Catholic care and the Bishop of Leeds did say the change only to allow for adoption for heterosexuals is motivated by religious belief, by my belief in what was called the Nazarene family, which was, it was the family in which Christ had been brought up, one father, one mother.
Yes.
So it was motivated by that. I have these underlying beliefs that the Nazarene family, and the best and only possible proper place for a child to be brought up is in a Nazarene family, is what he said. But as was pointed out, the evidence really wasn't thought through or convincing, because Catholic care had allowed for adoption to single people who didn't have a Nazarene family, and also that it was providing and facilitating adoptions for those who had no concept of a Nazarene family, who were not Catholic, who were not Christian, or the like. So although it was, as it were, subjectively motivated apparently, my desire to discriminate against you on grounds of homosexual or your sexual orientation is because I have these beliefs about where a child can best be brought up and a religious conviction about that.
But in both cases, you're not going to get taken on as a homosexual adopter.
But you're not going to be taken on as a non-evangelical Christian in our case, whereas you can be taken on as a non-Catholic in the Catholic care case. That's the important distinction. That's why and that's why we have to bear that in mind. It's a religion and belief.
Yes. Yeah. I'm just thinking of the case of a homosexual or homosexual couple who applied to each agency because no doubt they're impressed by their Christian values or something of that sort. From their point of view, it's going to be the same difference.
Yes, but for completely different reasons. I mean, and that.
Well, in the Catholic cases, I'm knocking you back because homosexuals don't fit with our edition of the family. In your case, I'm knocking you back because you don't fit with our conception of Christianity.
Yes, and that is a profound difference. That is a profound difference because we are dealing with a religion and belief requirement, not a sexual orientation requirement. Our religion and belief requirement might have implications, and does clearly have implications for sexual behaviour generally, but it is not focused, it is not specifically about homosexual behaviour. That's one of the specific issues of sexual
behaviour. But the judge did discriminate between the religion and the sexual orientation, and he was with you on one and he was not with you on the other, essentially because he considered that you could unpack the two,
yes.
Whereas you say that you can't unpack them.
I say you can't unpack them specifically in relation to section 193, and that's why I'm focusing on what 193 does. And I say this is important because Ofsted have misunderstood 193 from the note of argument, statement of argument as well, but certainly before the judge. So 193 doesn't allow for that kind of unpacking that the judge went in for. But as I say, staying with the letter of page 255, so first of all, we've made this, and this is a repeated point about the difference between our situation and that of Catholic care. We then say that we're not supplying goods and facilities for the purposes of the Equality Act, but that's a point that was argued but not been allowed to appeal on. And it points out that they are not discriminating on grounds of sexual orientation, but rather requiring standards of sexual behaviour common across sexual orientation. And in any event, so they try and let's start on the proper basis. Don't start with your misunderstandings that this is simply another Catholic care case. When you understand that this is a religion or belief requirement, it is from that starting point that you then carry out a proportionality analysis. Proportionality analyses are always dependent on the initial identification of the legitimate aim. And this, again, is potentially centrally important because, and I'll come on to develop this, Ofsted have not appealed against the finding that there is no breach of discrimination provisions or of the Human Rights Act as regards religion or belief by this religion and belief requirement. The judge has found, in fact, those requirements were justified. And that therefore, if they're justified, they can only be justified because they were pointed at a legitimate aim. And the legitimate aim, which follows from that finding of justification, is the preservation of the participation of a religious organisation as a religious organisation within a pluralist democratic society, providing charitable services to the broader public benefit in accordance with its religious beliefs. So, as I say, from paragraph 5 onwards, page 256, the justification is set out on that basis of what a proper legitimate aim is. So we're told that Cornerstone was founded to enable persons of the Christian religion to engage in providing fostering and adoption agencies. Unlike other agencies, it encourages foster carers to adopt children, and notwithstanding consequent loss of income to them because they would no longer have foster care allowance. And pointing out that Cornerstone has had unrivaled success in arranging successful adoptions of otherwise difficult to place children. And that is a matter which is accepted and spoken to in Ofsted's own report. Then goes on, a particular feature of the service offered by Cornerstone is Christian prayer and acknowledging and meeting the spiritual needs of fellow Christian Cornerstone foster carers. And that tending of the spiritual needs of the foster carers is said to be a central factor in avoiding the breakdowns with otherwise difficult children. They pray together, they get strength together, because this is a common, working in a common way for a higher religious purpose, say Cornerstone, in manifestation of its religious beliefs. Then, in fact, it gives greater resilience to its foster carers. And again, that's spoken to in Ofsted's initial report. Foster carers report they have greater resilience as a result of the prayer and spiritual support which they receive by common Christian prayer and common Christian faith. So Cornerstone then point out it wouldn't be possible to provide that spiritual prayer to those who are not fellow believing and practicing evangelical Christians. And because there has to be, in a sense, a unanimity in approach that what you're doing is appropriate and efficacious, that prayer works, that there is power in prayer.
Which paragraph are you reading out of at the moment? Is it 8 or?
It's 8.
8.
8.
Is there anything more you want from this letter, Mr. O'Neill?
Anything more? That simply that the religion belief restrictions are precisely what allow for the high quality adoption to be carried out, and that compliance with the code of practice is necessary to allow it to continue to provide a Christian childcare service. And if they don't have that, if they don't have the prayer, then they won't allow foster carers who are evangelical Christians might not be able to come forward. And the only thing I specifically note is the conclusion at page 257, where Cornerstone says it would be a pity if in the purported name of equality, plurality was destroyed. It would be even more unfortunate if the excellent work that we believe that Cornerstone does with most disadvantaged in society was prevented. And that remains an important and central issue, because the requirement which has been imposed by the amended report of Ofsted is that Cornerstone change its religion and belief requirements. And when we look at what that change involves, it means they have to cease being an evangelical Christian society in the manner in which Cornerstone has heretofore conceived that.
All right. And then we come to the last.
And the last letter is 11th January 2011. And as I said before, this is we've already seen that Charity Commission is aware that it has to apply a proportionality test that it's required to as a matter of the Equality Act, as well as the requirements of human rights. And it was precisely in response to that the proportionality analysis and justification has been set out in the previous letter. So on the 11th of January, they say, apologise for the delay in replying. I note your submission that Cornerstone is not discriminating on grounds of sexual orientation, and I accept that is correct, i.e. it's a behaviour requirement. Cornerstone is limiting the service it provides to prospective parents wishing to adopt children to parents who are evangelical Christians. We consider that requires justification, and you consider it falls within paragraph 2 of Schedule 23. Paragraph 2 relates to an organisation, a religious organisation. Cornerstone falls within that. Accordingly, Cornerstone is permitted to restrict the provision of its services if, for the purposes of the organisation, which has to be the religious purposes of the organisation, because the purposes of the organisation are set out in 2.1 of Schedule 23, or to avoid causing offence, grounds of religion.
But this is in two parts, this letter. The first bit is sexual orientation, and the second bit is religion.
Well, first of all, they say that there isn't a sexual orientation requirement. We accept that there is not a sexual orientation requirement. You're not discriminating on grounds of sexual orientation. I accept that is correct.
But that's the that's what this case is about, at least on appeal.
That's why we're coming on to what the finding is, section 193.
But I'm just looking to see what the reasoning is in relation to the issue with which we're concerned, because the rest of the letter, if I understand it, is to do with the religious element.
Yes.
With which we're not.
But we are. I'm sorry, my lord. I'm sorry to cut across.
Put me right. Yes.
We most certainly are. That is precisely what this case is about, is the religious belief requirement. And one cannot, and I say that the judge below made a fundamental error.
This letter is approaching matters in the same way as in the end the judge approached it, which was to consider both the religious and the sexual orientation issues and to treat them one by one.
With respect, my lord, I don't think this letter is doing that.
All right, I need to read it more carefully.
Yes, I think, and I think that is over-analysing a letter which is a letter in response to correspondence and long correspondence, and therefore has to be read in relation to its response and in relation to the requirements of the law as understood. What this letter is doing is saying that it understands that the Charity Commission is obliged to apply a proportionality test in accordance with section 1932A to the religion and belief requirements which have been set out in the charitable instruments lawfully under section 1931. So they are specifically and correctly applying the section 193 test by saying, let us look at whether those requirements pass the proportionality test.
Right, where is that in this letter? Just take me to the...
And so it says Cornerstone is permitted to, as a religious organisation, to apply religious belief requirements. Goes on, I would not take issue with your contention that at least one of the reasons applies in the case of your charity, and that you are entitled to conduct your charity in the way that you have chosen, provided that you can justify the restriction you have made in terms of the legislation. Please understand that this correspondence has come about from our wish to ensure all carers are treated in a similar way. I accept what you say about the different approaches in Cornerstone situation and that of Catholic care. However, the distinct approaches adopted by the two charities each required to be justified. Thank you for engaging with our concerns and providing us with the necessary information. We would not wish to question the value of the work Cornerstone is carrying out in providing prospective parents for children in need of adoption.
And you say that reference to necessary information having been provided is shorthand for the information which was provided in order for the Charity Commission to conduct a proportionality
under
exercise.
In terms of section 193, because that's what it told us in the previous letter.
Asked for.
Exactly. So this is the conclusion, saying, yes, we've looked at it, you provided it, and you've passed it.
Yep.
Just trying to work out what it means in the sentence which goes over 2 pages. Doesn't take issue with at least one of the reasons applying. And you can conduct your charity in the way you've chosen, provided you can justify the restriction. And different from Catholic care, but both need to be justified.
Yes. But if the Charity Commission having looked at the information, found that it was not justification, then they would have to find that what they were doing was unlawful, and that would therefore require the Charity Commission to then question the charitable benefits and charitable status of Cornerstone. But it has not done so because of the information that's been provided in response to the section 193 request. The charitable status has not been questioned, it has been maintained. So therefore there's been a decision that what has been done has been shown to be justified.
Well, that's one reading of this letter. I find this letter quite...
well, indeed.
It's perfectly apparent that the Charity Commission was not going to take up arms on this issue. That it expresses itself in relation to discrimination on grounds of sexual orientation and in relation to religious matters in a way that needs to be looked at carefully so one sees what they are and what they aren't saying. But there's no doubt, nobody disputes the fact that the conclusion reached by the Charity Commission was a matter of relevance. Ground one, of course, which we'll come to in its sharp edge, is whether Ofsted, as a result of this letter in effect and the correspondence that preceded it, had any business at all to be considering the equalities or human rights legislation, or whether in effect this is a free pass that puts an end to the matter.
Yes, that's what it comes down to, is how one reads the correspondence in its fullness.
Yes.
And what follows from that. Given that we have the statutory regulator referring to and asking for information to show justification in terms of 193, that information being provided, that information, as a result of that, no further action is taken in terms of questioning the charitable status, which the Charity Commission would be obliged to do if it found that what in fact what was being done was unlawful, and it has applied its mind to that in the light of the information which is provided. And as for the reading of it, as it looks at sexual orientation differently, and then it treats religion and discrimination, religion and belief discrimination
but effectively,
separately, that is a misreading.
Yeah. Well, when we come to wrap up on ground one, you're saying that this correspondence means that whether it be Ofsted, whether it be the Equality and Human Rights Commission, or any other body that might interest itself in issues of equality, discrimination, human rights, etc., that this is conclusive.
Yes, and that's because that is the purpose of the Section 193 approach, and the fact it is for the Charity Commission, with experience in charity law, to make the relative balance and judgment on the issue of the proportionality.
And it lasts for as long as you are a charity, or as long as the Charity Commission doesn't change its opinion.
Yes, and we haven't changed our objects. We haven't. These are precisely the documents, the requirements which we've been imposing for the past 16 years. There's been an investigation by the Charity Commission. They have passed by the Charity Commission under Section 193, and that's it. We haven't changed in any way at all. Yeah. Now, if the law, the understanding of the law changes, then the Charity Commission might wish to revisit it. On no doubt, Ofsted might say, maybe you should have a look at that again. Or an individual might say, I don't think you've understood the law properly here. Look at it again, but it would be a matter for the Charity Commission.
And so, taking it shortly, Mr O'Neill, we see here in the letter of the 11th of January the decision of the Charity Commission. You say that effectively binds others, and leading to that decision is the other correspondence and the documents provided by Cornerstone.
Yes.
Yeah.
I say this, that it's a conclusion which, and the decision is shown not just by the terms of the letter, and of course this is correspondence, not a statutory provision, but the fact that they have continued to work under the auspices of the Charity Commission ever since then, without complaint by the Charity Commission for the next 10 years.
And so the effect of that is that for organisations which come under the auspices of the Charity Commission, and I say it that way round rather than charities, if they satisfy the Charity Commission under Section 193, and they are, for example, a school, or in this case, a provider of foster and adoption services, then Ofsted has no further jurisdiction over those organisations in relation to matters of discrimination.
That is correct.
That is the consequence of what you're saying.
That is the consequence, and I don't shy from that, but that is because the Charity Commission has been specifically empowered by Parliament under and in terms of Section 193 to be the judge and regulator on this specific issue of the application and compliance with equality law by Parliament, whereas Ofsted has not. There is no express reference to Ofsted being entitled to become, as it were, the equality law policeman or the Human Rights Act policeman. But even if there were, the lex specialis here is charity law and the charitable regulator.
Just help me as to the Charity Commission's powers to, I mean, obviously it has the ability to correspond, which we've been seeing. What about its powers in relation to making decisions?
Well, it would be, there is of course an appellate structure set up.
Yes, but just at the level of the Charity Commission, of course, it can either register a charity or deregister a charity and so forth.
Yes.
But does it have a process by which it issues formal decisions? There was a reference earlier on in the Catholic Care case to decisions of the Charity Commission.
Clearly it does, because those decisions are, we've had references to the Charity Commission decision then being appealed then to the Charity Tribunal.
Yes, so this is not to be taken, this letter, as a decision of the Charity Commission. It is an expression of views, and it explains what the Charity Commission is or isn't going to do.
Well, no, it's a decision because it's on the basis of what it has set out in the correspondence that it has continued to act, which is to say accept the charitable status of the of Cornerstone, and has not said, as it would be obliged to, if it were to have considered that they were acting contrary to equality, contrary to section 193, then call into question its charitable status.
I suppose you would say, if one was to reverse the chronology, that if, and I know it didn't happen, Ofsted were to have raised this issue first, before it had been considered by the Charity Commission, and Ofsted was to have reached the conclusion in 2008, 2009, or shortly before this letter in January 2011, that this was unlawful and had reacted accordingly. But the Charity Commission had then gone on to consider the matter. Then by virtue of this being a charity, it wouldn't just be that Ofsted had no jurisdiction, but that it had no jurisdiction previously, and that its previous conclusion was null and void.
Yes, because effectively Ofsted would be purporting to apply the section 193 test of checking what's in the charitable instruments, checking whether benefits are applied under it, and whether that's proportionate. Whereas that is not the task that Ofsted is given under the Equality Act. That's a task which the Charity Commission is properly to be doing.
All right. Now, a lot of what you've been describing to us in this correspondence is very valuable in relation to later grounds. So, although we've taken some time on this, for my part, it's not been time wasted. But are we now going to be able to pull ground one together?
I do hope so. The first point I would make is that if one passes, first of all, section 193 says that if one passes the tests set out there, is this in your charitable instruments, and is it provision of benefits, then the section says that the charity does not contravene this act. It doesn't say the charity does not contravene aspects of the act. It does not say the charity does not contravene a particular characteristic of the act. It says it will not contravene this act. And that is important, as I say, from a policy point of view, because as we see in discussions in the Zedd case, which we'll come on to, part of what the policy is that the Parliament is seeking to protect charities from having to undergo too many regulatory requirements and hoops and potential litigations and challenges, and is allowing matters to be set out and finished, as it were, with a judgment of the Charity Commission, always bearing in mind the overall chargeable benefit test which it has to apply.
But 1932 requires the provision of benefits to be a proportionate means of achieving a legitimate aim.
Yes.
That's an objective matter. It doesn't say the provision of benefits in the opinion of the Charity Commissioner or the regulator is a proportionate means.
Yes, but it is clear that from certainly 1938 that the decision is one, and certainly the Charity Commission in this case has exercised that section 193 decision, but 1938 refers to the Charity Commission as being the judge on issues of compliance with equality law, and that it does not contravene equality law by making the decisions which it has made.
And remind me, where does it say that that's the Charity Commission's job?
It's the relevant. It is identified in section 1945 as the relevant regulator of the Charity Commission, and it's referred to in 1938. Sorry.
Yes, we've got sub 8, which just deals with the position of the regulator itself.
Yes.
Did you say it's 194?
1945 describes who the charity regulator is for the purposes of 193.
Well, so your argument depends upon the identification of the charity regulator as being conclusive as to who is the arbiter of the compliance with 1932A.
Yes, and I say that that comes from a broader understanding and appreciation of charity law, and there has been some discussion of this in aspects of the case law. For example, in the Father Hudson Society, Mr Justice Briggs, and that's at tab 14, might as well turn that up, with the authorities bundle, page 379.
Is that tab 9 or tab 10?
14.
Tab 14.
Sorry, there are so many of them. Yes.
I know, I'm sorry.
No, sorry. Tab 14.
And it's paragraph 110. As the court will recall, this was the decision primarily about whether or not Regulation 18, as it when was now, Section 193, could be paid in aid in relation to charitable benefits provided to foster carers, not simply to children. The court found that it did. That having been found, the issue as to whether or not there was a justified restriction arose, and the question was, well, who was to make that decision? And part 110.
The only candidates in that case were the Charity Commission or the court.
Or the court.
I obviously don't have
But what it says,
thorough knowledge of this decision, but at the moment I'm not understanding what its relevance is, or what the relevance of that very expected conclusion in the context of that case would be for other regulators.
because what it says is that the Charity Commission is the body charged by Parliament with the task of carrying out.
But he wasn't saying, and it wouldn't be for other bodies who are equally charged by Parliament with inspecting equalities legislation.
Yes, but what we do know is that that in this judgment, it's the Commission which has been charged by Parliament, which is what I've been saying is the proper interpretation of 1.
Is that the size of it, paragraph 110, and that...
No, there is further case law, and I will come on to it, my Lord, but
I'm interested in anything that says it's the Charity Commission and not some other body.
What is said, it is the Charity Commission to decide on issues of charity law and charitable benefit, because they know what the balances are and the importance of the operation of charities.
This is not a question of charity law.
Yeah. I'm sorry, Lord?
What we're concerned with in this case is not a question of charity law, although it may be relevant to the exercise of charity law.
Yes, but specifically in relation to 193, that has to be understood in terms of charity law, and that's what the case law tells us. And given that we know that from Mr Justice Briggs that Parliament has charged the Commission with the 193 test, and then we know that 193 has to be applied against the context and against the background of charity law, then those who are not charity regulators would not be best suited.
Is the judge here deciding that it should not be he who carries out the analysis of justification, but the Charity Commission?
He says...
Isn't that the dichotomy that he was addressing?
He says the Commission is the body charged by Parliament that hasn't carried it out, provided it directs itself or is directed correctly in law, it is better resourced and, in my judgment, better placed than the court to provide that difficult function.
Yes, but presumably the issue in that case for him, having got to this point, was in the light of my conclusions, am I now going to make the decision, or is the Charity Commission going to make the decision?
The decision being, it's the justification decision, it's the
yes.
proportionality decision. And he's saying it's better placed for the Charity Commission, not just because of its resources, but the fact that it is a specialist regulator and it is better placed than the court to perform what is accepted to be a difficult function. Yes. It is the one which makes the final decision and balance. It may then, if it has misdirected itself in law, be then questioned. But the decision on the proportionality is a decision on the proportionality and is not to be opened up by other regulators or by the court just because it thinks I would have reached that proportionality differently.
I've understood the submission.
As he says, going on, the only reason why the Charity Commission has thus far not discharged that function is that in its search for a ready means of confining Regulation 18 so as to avoid it becoming carte blanche for publicly funded faith adoption agencies, it has alighted upon a wrong interpretation of Regulation 18, so it appeared to it that justification exercise was unnecessary. But I have no reason to suppose that directed to the proper interpretation of Regulation 18, the Commission will not be able to carry out that analysis on the facts thus far provided or on the basis of further evidence. So it's an evidential matter, and again, a matter for that as the decision maker. And it's a proportionality analysis by that decision maker, better placed for all the reasons set out than the court. The other point, so I've noted first of all that section 193 provides that if a charity is held to pass the test, then it doesn't contravene the Act, rather than doesn't contravene specific provisions of the Act, to which it doesn't contravene the religious belief. And I've set out why that broader notion is in line with Parliament's policy. The second point I wish to make is that direct discrimination because of sexual orientation in the provision of charitable benefits can be found under the section 193 test to be justified. Section 193 is applying a different test, is applying a proportionality test, whether to indirect or to direct discrimination, and on whatever protected ground one takes. So it's a different test from that being applied under section 13 and 19, or 13 in particular. And authority for that is to be found in the later decision in the same line of cases of Mr Justice Sales, as he then was in the upper tribunal. That's at tab 10, page 214. I'll just highlight a number of passages from that, but the point being that direct discrimination, unlike in the normal approach in discrimination law, can be justified under terms of the section 193 test. He says at paragraph 38, page 229 of the authorities bundle, paragraph 38, if as a consequence of some people having prejudices about or negative attitudes towards homosexuals, some real detriment to the general public interest of sufficient weight might arise unless the practice discriminating against them were adopted, then in principle it's possible that under Article 14 and Section 193, for such a practice to be found to be proportionate to the legitimate aim of preventing that detriment or harm. So he goes so far as to say it's not just direct discrimination, but even prejudicial approaches. But the important point to contextualise in this case is that he's dealing with, because this is a Catholic care case, an attempt to impose a requirement which specifically and expressly seeks to discriminate on grounds of and only of sexual orientation. He's saying in principle that can be justified under section 193. Paragraph 41, he notes the authorities of Strasbourg authorities stating that differential treatment against homosexuals can be justified by particularly weighty or convincing reasons. So the interesting thing about that is Ofsted relies on saying this can't be justified because they're not convincing or weighty reasons, and in a sense Mr Justice Sales then was saying, well, it's showing that it can be justified if the reasons are and again, this is specifically about direct discrimination on and about sexual orientation.
Sorry, so that was paragraph 38, and then you went on to paragraph
41.
Thank you, and that's what you were
And then, but 42 makes it completely explicit, where bottom of page 230, about 5 lines up, sentence beginning under the statutes. That's the
Yes. So at the
domestic
bottom of that page, isn't it?
Yeah.
Is the
There's no scope for justification of direct discrimination. The only question, by contrast, under Article 14, Section 193, direct discrimination, such by reference to protected characteristics, is capable of being justified if objectively justified on the facts. Paragraph 45, again picking up on this issue about, well, this is just prejudice and discrimination, and there shouldn't be any justification exercise. Notes that third-party donors, and this is specifically again on highlighting the charity aspect. The third-party donors are motivated by sincerely held religious beliefs in line with a major tradition in European society, such as that represented by the doctrine of the Roman Catholic Church, particularly whereas here their activities don't dominate the public sphere in relation to the activity in question, namely provision of adoption services, which are otherwise widely available to homosexuals and same-sex couples.
Are we straying a bit away from ground one here? I mean, isn't ground one the locus of Ofsted in the first place?
Yes, but I mean, it is the locus of Ofsted, which is ground one, but I'm attempting to, I mean, I could come back to this case under ground two, but just because we've got it here, I was hoping we could
All right.
get through it. But the point is that, which is made in paragraph 45, is that donors motivated by respect for Roman Catholic doctrine to have and the reason I pick it up is because these are considerations about third-party donors and legitimate aim and proportionality, which are then picked up and explained by Lord Sales as he had become in the Zedd case, and that's why where he's preparing the groundwork for that by referring to in a charity the position of.
Right. So these are matters that are relevant wherever the proportionality exercise is being conducted.
Yes, those issues are, and donors motivated by respect for Roman Catholic doctrine to support adoption within a traditional family structure can't be equated with racist bigots. There's a place for such views in a pluralist, tolerant, broad-minded society. And in relation to that particular requirement of can we show that our attempt to directly discriminate against homosexuals on sexual orientation grounds without reference to religious requirements, again, Mr Justice Sales says, well, that could be justified, paragraph 52, adopting the position taken by Ms Carrs-Frisk, that if the charity, that's at page 234, if the charity were able to show that there is a significant prospect that more children would be placed into adoption if it is allowed to discriminate against homosexuals than would otherwise be the case, then the interest of charity would be so placed, provide an argument in permitting the charity to proceed in that way. And then finally on this, at page 60, paragraph 60 to 61, at page 237, says the strong likelihood, middle of the page, middle of paragraph, sorry, it's at letter D of page 237 or 2128.
The strong likelihood?
The strong likelihood
yes.
is that same-sex couples would use other freely available adoption services and would avoid the charity's adoption service if it pursued a declared practice of excluding homosexuals from the service rather than proceeding to apply to charity, being subject to demeaning experiences. It is unlikely they would be deterred altogether from entering the adoption system. In consequence, I think the first-tier tribunal was in error for rejecting the charity's argument it could potentially increase the number of adoptions by increasing the number of potential adopters who approach the charity. And in Re G does not support that. So, as it turns out, on the facts of that case, there were not found to be sufficiently weighty reasons to justify the attempt to impose a new requirement of discrimination on grounds of sexual orientation. But in principle, it was possible As I say, but the main reasons for drawing the court's attention to this case is that Section 193 applies to claims of direct as much as indirect discrimination, and that the issues of donor preference, of the charity's ethos, are relevant factors in any proportionality analysis, as is the possibility that the charity will close down if not allowed to change its objects in this case, with the consequence that adopters specific to that would not approach it. Now, those are all relevant factors. As it turned out, they were not found to be sufficient in the circumstances of the case for the attempted change, but it's useful in terms of the relevancy of matters. And I say that the proportionality test under Section 193, in a sense picking up Lord's comments at the opening, is in that sense of taking everything in and seeing whether or not, on balance, and it's a judgment of a decision maker on balance, has been reached. It is akin to the proportionality test required under the Human Rights Act or the European Convention on Human Rights. The authority for that is a case of Rodriguez against the Minister of Housing, which was produced yesterday in the supplementary bundle, but it's simply at paragraph 18, where the Privy Council in that case, which concerned a restriction on joint tenancies to those who were married, joint tenancies in Gibraltar to those who were married or who had a child together, that was said to discriminate as indirect discrimination on grounds of against same-sex couples. And so it's said to be indirect discrimination on grounds of in relation to sexual orientation. But it just usefully points out that one doesn't have to get bogged down when doing this, that proportionality exercise in, is this direct discrimination, is it justified or not, what is the how do you define the comparators and the like. You take a broad approach and you just essentially say, according to Lord Nicholas's, which is quoted with approval, the essential question for the court is whether the alleged discrimination, that is the difference in treatment at which the complaint is made, can withstand scrutiny. Sometimes the answer will be plain, there will be sometimes obvious and relevant differences, sometimes the position is not so plain. The court's scrutiny may best be directed at considering whether the differentiation is a legitimate aim and whether the means chosen is appropriate and not disproportionate in its adverse impact. And as I say, they are primarily balancing judgments, so it's the same kind of thing. 193 and the Human Rights Act 14 are doing the same proportionality exercise. So in sum, I say that in holding that Cornerstone's religious belief requirements and its, which as we know follows on from it, are restrictions on persons' acceptable sexual behaviour. In finding that the Section 193 test has been passed, the finding of passing Section 193 is not a finding that there has been no unlawful discrimination because of others' religion or belief. It's simply that there has been no contravention of the Act's other provisions, and that's the, as it were, the one-stop shop for discrimination law, which Section 193 applies. Now, if I can just deal with certain of the counter-arguments put forward by Ofsted. First of all, Ofsted says that all it has to do is have regard to the Charity Commission's decision, and then is free to ignore it and come to its own decision. In a sense, it appears that Charity Commission is concerned only with a specific narrow issue of charitable status, whereas Ofsted can reopen the whole matter in relation to being an independent fostering agency. But as you've said, if it is guilty of unlawful discrimination, then it will lose its charitable status and it would be acting unlawfully. It wouldn't be able to continue, not just as an IFA, but not able to continue in its charitable not-for-profit status. So, and the analysis, and it's worth looking, I think, before we rise for lunch, at the Zedd case, which I've mentioned before, because this is the central case in terms of how one has to understand charity and Section 193 as an implicit part of charity law. And that's to be found at tab 33 in the authorities bundle, at page 994 of the bundle. This was a decision concerned with whether or not the housing allocation policy, which was permitted by Hackney Council to a housing association that was specifically intended to support Orthodox Haredi Jews, had to be subject to a proportionality test, and if so, whether it passed that proportionality test. As it turned out, the Supreme Court held that it wasn't necessary, in fact, to undergo the 1932A proportionality test, because Parliament had decided under 1932B that the protection of a disadvantaged group didn't have to be shown to be proportionate. But it is important, as I say, as a general overview of the equality law requirements and interrelationship with charity. So if we look first of all at paragraph 80 in the judgment of Lord Sales.
80 or 80?
80, apologies,
Thank you.
Page 1021. So the paragraph starts off with a reference to 158, which is the positive action provisions, but it then goes on at page 1022. Similarly, in the context of section 193, charities typically focus the benefits they aim to provide on defined groups. Charitable status is a way of recruiting private benevolence for the public good, subject to the public benefits task, and charities focus on providing for particular groups, since that is what motivates private individuals to give money. So we're coming back to the reference to the Catholic donors, where they feel a particular link or concern to the groups in question. It is for the public benefit that private benevolence should be encouraged for projects which supplement welfare and other benefits provided by the state, even though those projects do not confer benefits across the board. Accordingly, Parliament contemplated that the proportionality measures falling within section 193 should be assessed on a group basis by comparing the advantages for groups covered by the measure in question with the disadvantages for groups falling outside it. So it's a different kind of approach in terms of proportionality. It's group rather than individual based, so it's not enough for one individual to say, I'm being disadvantaged for this. One takes the broader view. Going on to paragraph 98, page 1029, notes that charities have been subject to legal regulation for a very long time. Particular charitable status is limited to bodies which provide public benefits of specified kinds. For a purpose to be charitable, it has to fall within section 3.1, and that includes prevention or relief of poverty, advancement of religion, and relief of those in need because of youth, ill health, disability, financial hardship. And the Charity Commissions exercises regulatory oversight in relation to activities of charities to ensure, among other things, that the public benefit requirement is satisfied. The public benefit requirement will not be satisfied if a charity's activities have been unduly detrimental if wider effects in society. So again, the maintenance of the charitable status means a judgment that the charity's activities are not having unduly detrimental wider effects in society, says Lord Sales. Going on to paragraph 101, there's some discussion about the genesis of section 193, and it's noted that when the Equality Act 2010 was a bill in Parliament, the Joint Committee on Human Rights sent a letter raising a number of queries, including about section 193. The government response explained the exemptions from anti-discrimination law were to be tightened up, so to bring the new provision in line with the sex discrimination model, so it would no longer be sufficient to show there was a chargeable instrument, but there will also have to be justification. And justification would be achieved if such discrimination is objectively justified under section 1932A, that's the proportionality test we've looked at, or is intended to prevent or compensate disadvantage linked to the protected characteristic, which is 1932B, which we're not relying on. It's clear from the provisions, proposing the provisions, the government intended paragraphs A and B to serve distinct conditions for the operation of a charitable exemption. Consider the satisfaction of either of them would constitute justification for discrimination, which would also meet the requirements of EU law. In this case, we're not in the, at least on the, yes, we're not in the ambit of EU law, as it turns out, because it's service provision and requirements relating, say, Ofsted to sexual orientation discrimination, and we say to religion and those, whereas employment issues or work-related issues are covered by EU law. This is not an EU law area. Paragraph 103, the general regime for regulation of charges in English law limits chargeable status by reference to defined public goods and by application of the public benefit tests. And that ensures that benefits to be provided by a charity are balanced against any detriment from its activities. As a result of this regulatory regime, the requirement in section 193A that a person seeking to benefit from an exemption has to act in pursuance of a chargeable instrument imposes substantive requirements that the acts in question promote the public interest. Now again, these are all issues of which the Charity Commission will be aware, because this is the issues which arise from charity law, in which someone like Ofsted will not necessarily be aware, but also the fact is it shows there is a different regime and different approaches, precisely because we are talking about charities. It goes on, the EHRC Code of Practice public benefits test that all charities must satisfy to gain charitable status may assist, doesn't guarantee the restriction meets the Act. The charity regulator has still to consider likely impact on restrictions and whether such restrictions is justified in assessing whether the public benefit test is met. So again, this tying up of the analysis and conclusions to whether it can continue as a charity. In the context of general anti-discrimination laws contained in the Equality Act, it was abundantly obvious that issues under both EU law and Article 14, and again, so this is in a sense picking up what your Lordship was asking from the outset. In relation to activities would fall within section 193, Parliament acting with the benefit of the explanation from the government referred to above must be taken to have taken the assessment that by this combination of conditions, the regime enacted satisfied the requirement of proportionality for the purposes of EU law and ECHR law. Going on in 106.
And the last sentence also very important there in 104, must equally be taken to have considered that the regime satisfied the requirement of proportionality for the purposes of the ECHR, in particular as it arises under Article 14. So you would say, hey presto, once it's proportionate under 193, it's proportionate under Article 14.
Yes, and I'd rather brusquely summarise that, but
yes, but I just thought it.
Yes, no, I'm grateful to your leadership for that.
What I'm not so far understanding is how this feeds into ground one, because the housing association in this case was a charity.
Yes.
This is not. This was a public law claim brought by some individuals who were dissatisfied with being excluded from the group of people who might be housed by this organisation.
I think they were dissatisfied by the council's acceptance of the ability of the policy adopted.
So at one remove.
Yeah.
Why is the answer to that in this case then not, well, it's justified because they're a charity.
Why is the answer to which case? Sorry.
Well, why is the answer to that problem? Well, they're entitled to discriminate because they're a charity. The Charity Commission has accepted them as a charity and end of.
Yes, well, that's what the court is saying in the Zedd case. Sorry, I don't think I've understood your lordships.
Well, I think we may be at cross purposes then. This is not a review of the Charity Commission's decision to accept the Housing Association as a charity. It's a freestanding public law challenge to alleged discrimination. And the court, all the way up to the Supreme Court, is working its way through these matters in order to see whether what has taken place in this case is or is not justified under, in this case, actually sub B of 1932, but the principle, as you say, applies equally in its different way to sub A. But it's, for the purpose of ground one, it isn't saying, well, why are we doing all this? Because the Charity Commission has already accepted that this is a charitable organisation and can operate in this way. What's the difference between this case and our case?
The difference in this case is that what was being challenged here was a decision of the local authority to accept the policy as being operated by...
Yes, but it focused in the end on the same question, which was whether it was justified to exclude people who were not part of the Haredi community from making housing applications. And it was found that it was justified because of the disadvantage that community experienced in the local conditions. But I don't understand why you couldn't, if you had been represented, you couldn't have stood up in that case and said, well, we needn't worry about all that because the Charity Commission has accepted us.
Well, I mean, I don't know the details of it, but I don't know if in that case there had been a decision, as there was in our case, on Section 193, and what was being, as I understand it, what was being attacked was the local authorities' acceptance of the lawfulness of the Housing Association's approach, and that the Housing Association, and that was because what the Housing Association was doing was lawful, both as a matter of positive action measure under Section 158, and separately because it was a charity dealing with and providing for those suffering at a particular disadvantage. By the time it came to the Supreme Court, and a whole proportionality analysis was carried out by the Court of First Instance in that case, by the time it got to the Supreme Court, they said you don't have to be doing a proportionality analysis. You just have to be checking for justification under 1932b, which is distinct. But the reason I'm referring this case to this court is it is the longest discussion about Section 193 and what the intention of Parliament was in passing it and what its implications are and why it is based and founded in charity law. And as I say, so it contains useful insight and guidance on the relationship between Section 193 and equality law as a whole, that it's a distinct regime, and it's a distinct regime for good policy purposes in relation to charities. And it is one which is, as we've seen before, to be carried out by the charity regulator, the Charity Commission, which is because it is tied up and inextricably linked to findings of this being a charity carried out for public benefit in relation to purposes which are contained in charitable instruments which have been approved of by the Charity Commission. So I don't know if that's answered the Lord's
Yes, thank you very much. Good. Now I see the time. Would that be a convenient moment, or do you want to finish Zedd? Was there anything else in that file that you wanted us to look at?
There were a few more. I can come back and deal with Zedd.
Right, now how you've been burdened by a lot of discussion, particularly from me, and so how are you doing?
I'm certainly not going to be finished by lunchtime. I think I'll be lucky if I finish today, I'm afraid.
All right, well, we'll try to be mindful of the of your situation when we return. But we'll sit to 4:30.
Yes.
4:30. We'll sit to 4:30 today, and would you please discuss between you that if you're not going to finish this afternoon, how much into tomorrow it would be reasonable for you to go. So to
I would very much hope to finish this afternoon.
Yes. Well, we won't.
But if we don't, then
we won't give up on that.
And also, I'm more than happy for the court to give me a deadline, and I'll stick to it.
Right. Well, we leave it for you two to discuss, and see you again at 2 o'clock.
All right. Stop the live stream now, and as I said, there's a 90-second delay. Anything